Welcome back to the program. I'm joined now by John DePippa. He is Distinguished Professor of Law and Dean Emeritus at the Bowen School of Law at the University of Arkansas at Little Rock. I'm pretty close on that title.
Good morning.
It's a great title. Thank you for being here.
You're welcome.
So, before we get going into much of anything here, Justice Robin Wynn passed away this past week. The legal community in Arkansas is a small, tight-knit one. You probably have some thoughts on Justice Wynn.
Sure. I mean, it's really a tragic loss because Justice Wynn was a good guy and a good judge. I think universally well-liked and universally well-regarded as a very thoughtful and very diligent judge.
Yeah, well, he certainly, I've not heard anybody say anything negative about Justice Wynn, so our thoughts are with his family, and we will keep them in our prayers as well. All right, two big lawsuits this week kind of took center stage in politics in Arkansas. Let's begin with the federal ruling from Judge Jay Moody on this transgender medical care case. He ruled in favor of the plaintiffs. And a part of the argument in all this was not only the First Amendment and their free speech rights, but the 14th Amendment, I think on a couple of different levels, quite frankly. Explain to me how the 14th Amendment, which I always remember as being the one that freed the slaves, has anything to do with this transgender medical care issue.
Well, the 14th Amendment actually has two provisions that protect rights. There are more, but there are two involved in this case. One is called the Equal Protection Clause, and that guarantees that people are treated similarly. Similarly situated people are treated the same. And then the other is the Due Process Clause that protects certain rights. And what Judge Moody ruled is that the law in Arkansas violated both the Equal Protection Clause and the Due Process Clause. And so you have to sort of get into some weeds here, but let's try to. So it's impossible to treat everybody exactly equally because not everybody is similarly situated. We're not all the same. So, for example, we restrict children more than we do adults because we have a good reason to restrict children. They're not as mature, not as physically capable, they're not able to think through a lot of things. So the law says you don't have to treat children the same way you treat adults because you have a good reason to make that distinction. Well, when you apply equal protection law, the court asks the same question. Is there a good reason to treat this group differently than this other group? And what Judge Moody found under the 14th Amendment Equal Protection Clause is that the state didn't have a good enough reason to single out gender-affirming care for trans youth. Because the state's arguments were, hey, we're just trying to protect children. And all the evidence showed that, in fact, gender-affirming care protected children, did better for them. So the state's justification, we're going to protect children, just fell apart.
Yeah, there is some citing of some medical evidence that is sometimes discredited. The Attorney General, Tim Griffin, actually said it in his statement on Judge Moody's ruling and in his effort to appeal this case, which will go to the next level, that it bucks some of the medical evidence out there. But Judge Moody was pretty clear that it did not buck the medical evidence out there. So,
that's right.
Also, and on the First Amendment ruling, that was just simply free speech. They have the right to engage.
Well, the First Amendment ruling is actually the First Amendment rights of doctors, because the law prevented doctors and other physicians and medical personnel from referring trans youth for gender-affirming care. And the court said you can't restrict their speech. Even if you could prevent them from providing the care, you can't restrict their speech in telling people where this care is available.
Yeah. So this goes to the 8th Circuit Court of Appeals. That's where a federal case would get referred to. Maybe describe that process a little bit. And it's a lengthy process. This won't be like in 3 months we won't be having a determination on this.
It will take several months, if not a year. I mean, the state can appeal. Usually, when the 8th Circuit hears the case, they'll hear it on a panel of judges, say 3 judges. Those will take briefs, hear oral arguments, then make a decision, and that could take months. Then, whoever loses before this panel has the right to ask for the full 8th Circuit, which is 12 or 15 judges, to hear the case. And that can take another several weeks. And then the loser of that can appeal to the United States Supreme Court.
Yeah. Do you think this is a case that might work its way to the Supreme Court? Because there's been about, I want to say, 19 states. I mean, there's quite a few states that have passed some similar laws here. Arkansas seems to be the first one to move through the process.
That's right. We were the first state to pass a law restricting gender-affirming care, and this is the first decision to reach a permanent injunction. And some other cases have done what Judge Moody did last year, temporarily prevent the laws from going into effect. So this one's way in front of all the others. The issues are significant enough that it's possible the Supreme Court would take the case. We'll know if some of these other cases come out in the other direction.
Gotcha.
If the state wins some. Supreme Court's likely to take a case when there's a conflict among the lower courts over the right way to resolve a case.
Gotcha. All right, let's turn our attention to the state courts here. The LEARNS Act had a hearing this week. The central issue of that case, there are several parts, but the main one is over the constitutionality of the vote on the emergency clause that the legislature did. The Constitution has conflicts in it. The state Constitution does. We have this emergency clause language that's in there. You've got a law that lets the Arkansas legislature do its own rulemaking, and then you've got this sovereign immunity that where the state can't be sued. What do you do when all of those things are in conflict with each other?
That's what makes this case so interesting and complicated. So let's take the first one. The Constitution, just like every Constitution, says the legislature can make their own rules. And then each Constitution has a set of procedures before something can become a law. And that's where the conflict arises. And what the plaintiffs are arguing is the rule requiring a separate vote on the emergency clause is just like the rule that requires both houses to pass a bill. I mean, the House couldn't decide, hey, you know, we're just going to not vote on things this year, let the Senate take all the work. That would violate the Constitution's procedure. And the plaintiffs are saying the separate vote on the emergency clause is just like that rule. Now, the government's arguing a little different.
Yeah.
I mean, the structure of the government with, say, two different houses, that's structural. That's crucial to the whole architecture of the state. This is just an incidental thing and falls within the purview of the legislature to make their own rules, just like they can make their own rules about how long a vote will stay open before the vote closes.
And on the sovereign immunity clause, this is something that hasn't been resolved in several years from a Supreme Court ruling that said, yes, it's pretty crystal clear the state of Arkansas cannot be sued in her courts. Yet we still see the state of Arkansas being sued in our courts. You're going to have to resolve this conflict for me, Professor.
I'm not sure I can. And so, but I will compare it to what the federal government does. And maybe that's the way that Arkansas can figure its way out of this. The Arkansas Constitution is very clear. It says you can't sue the state for any reason. But that would prevent so many people from legitimately raising claims about their constitutional rights or the way the state operates. The federal government has a sovereign immunity rule, but it just prevents people from suing the government for money damages. It says there's no reason why you couldn't sue a government official to stop them from implementing an unconstitutional law, but you can't sue them to get money from them. Arkansas could resolve their sovereign immunity conflict the same way, and they haven't yet.
It would take a constitutional amendment to do that, would it?
Or it'd take the Supreme Court saying, this is what the sovereign immunity clause means.
All right. We'll see if we can get them to make some more interpretation on that. John DePippo, always a pleasure to visit with you. Thank you for your insight. Very appreciative.
Welcome.
All right. We're back with more with Chief Justice candidate and Supreme Court Justice Rhonda Wood right after this.